736FY. This is State of Michigan versus Frank Micho. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Micho. I am a beneficiary of the Frank Anthony Micho estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Micho. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Micho, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Micho make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action. And I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction of the court. Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Micho, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover, contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm, contrary to MCL 750.227B. There's also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter. The court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
No. You still haven't stated.
Welcome back to the chaos that is Frank Micho versus reality. Part 4. We're heading once again into Judge Green's courtroom, where Michigan's most persistent pseudo-legal philosopher tries his hand at courtroom improv. If you thought Part 2, his meltdown with Judge Oakley, was wild, buckle up, because today's episode tests the limits of patience, logic, and legal sanity. That I in this corner, we've go asterisk, calm but clearly exhausted, armed with a gavel and infinite patience. In the other corner, a self-proclaimed beneficiary of his own estate, still trying to convince everyone that the courtroom is actually a monopoly board. That what's at stake? 3 felony counts involving firearms, a criminal record that reads like a mixtape of bad decisions, and one man's unshakable belief that saying special appearance is the same as a legal defense. Will Judge Green keep her composure? Or will Frank finally learn that jurisdiction isn't a get-out-of-jail-free?
To you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Micho, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as.
Here's where things start spiraling. Frank opens with his sovereign citizen classic. I am the beneficiary of the estate you are administrating over. In his mind, he's rewriting property law on the fly. But what's actually happening? He's facing felony firearm charges, serious ones. And no amount of pseudo-legal jargon changes the fact that Michigan courts recognize statutes, not trust Judge Green, to her credit, plays it smart. She lets him talk, logs it all into the record, and keeps the courtroom calm. But notice the power dynamic. Frank believes he's in control because he's appointing the judge as trustee. Spoiler.
You're not under any threat. This is a court. You've appeared this afternoon. This case has been called. And if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15.
we just.
And the courts, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed, so you're not actually giving me the right to answer the question. You also making it seem like you're threatening me, so
Mr. Micho, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so,
I've answered all that needs to be answered from this court to proceed with either the exam,
you
a
haven't-
waiver.
Okay, all right, but you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask.
Sovereign Citizen video has this moment, the jurisdiction tango. Frank insists on knowing the jurisdiction of the court, as if the word itself is a magic incantation that banishes criminal charges. He's already been told multiple times, both by Judge Green and Judge Oakley, that the jurisdiction is Astra's criminal law, Michigan State, but he just keeps circling back. This is a common tactic in sovereign ideology. They think if they don't consent to jurisdiction, the law can't touch them. But courts don't work on consent.
The question. So do I have the right to?
What's your question, Mr. Micho?
I just want to ask you, far as. Hold on one second. I want to read this for you.
No, sir. You had a question. What is your
Okay.
question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
it says that possession of a deadly weapon is a commercial crime. So we have to I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this
Mr.
civil or criminal? Because it doesn't make sense.
When Judge Green patiently breaks down, it's a masterclass in judicial composure. She lays it out. Asterisk felon in possession, concealed weapon, and felony firearm. Asterisk that a trifecta of bad decisions, each carrying years in prison. And yet, Frank's only response? What's the jurisdiction? This is the dramatic irony at play. A man accused of bringing a gun to an airport is arguing semantics while his freedom ticks away. Notice how she references the Michigan compiled laws. She's grounding everything in statute, while he's floating in pseudo-legal fantasy. It's calm versus chaos.
Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions you wouldn't
You
respond.
can practically feel Judge Green's patience thinning here. Frank has asked about jurisdiction again. She's identified the 34th District Court and even referenced his prior rulings. But this isn't about confusion, it's defiance. Frank's argument isn't meant to win. It's meant to asterisk stall, and if you caught her tone, it's shifting from polite to procedural. She's giving him three options: proceed, waive, or adjourn. This is Judge Green reclaiming control. Frank doesn't realize it, but the court's already seen this movie before. He's just pressing repeat. And in Michigan courtrooms, repetition doesn't.
And Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Micho.
Moment. Frank, under threat, duress, and coercion, tries to appoint his defense attorney as his trustee. The mental gymnastics here are Olympic level. He's mixing trust law, contract law, and total nonsense into one breathtaking display of courtroom chaos. Then the narrator and me has to admit, appointing your lawyer as trustee might actually be the smartest thing he's done, even if it's for the wrong reason. But Judge Green isn't taking the bait. She calmly clarifies that Mr. Sullivan is his attorney a trustee, subtly putting Frank back in his legal lane without escalating the situation. Professionalism,